As many of you probably know or have witnessed just being on the internet for the last few weeks, Max just released a documentary called Quiet on Set, which details the inappropriate behavior and toxic culture behind a lot of shows that we grew up on. The things covered in this documentary range from revealing Dan Schneider's inappropriate behavior in the writer's room and with child actors, to gross innuendos written for child actors on children's programs, to literal crimes of essay that are coming to the public light for the first time. And last week I went out with some friends and we were talking about how horrible the stuff in this documentary is, and one of my friends was like, "F it, maybe we should just ban child acting." And I was like, maybe we should. Obviously, that was a very bold and emotionally charged statement that we were making with really no basis besides this documentary, and we didn't really fully believe. But it got me thinking, how protected are children? If a child and their parent or guardian are new to the industry and they don't know the inner workings of it, can they really make an informed decision on letting their child be a employee basically in the entertainment industry when it could lead to trauma that alters the course of their life? So I went down a rabbit hole, as one does, and I started reading up on child entertainment laws in the United States, and it's insane. It's garbage. I found myself at the end of this deep dive really believing in the necessity of federal regulation on child entertainment laws, and today I'm going to explore why, including a brief history on child acting in Hollywood and how both parents and the industry fail child actors. So over 100 years ago, people were living in conditions in which child labor was normal. Children were working in factories and mines, but it wasn't until the 1930s that there was any proper legislation restricting that. But obviously, Hollywood and child acting existed before the 1930s. One of, if not the first notable child star, was this kid named Jackie Coogan. If any of you cinephiles have watched Charlie Chaplin movies, Jackie Coogan played the kid in this film, The Kid. He also later, when he was an adult, went on to play Uncle Fester in the TV series The Addams Family. I will circle back to Jackie Coogan and Coogan's Law in a bit, but I first wanted to cover the infancy doctrine to really set the stage for what child acting has looked like from the very beginning. The infancy doctrine, a fundamental aspect of common law in the United States, centers on this legal presumption that minors can't fully understand contractual agreements due to their age. This was established in California in 1872, but this doctrine basically gives minors the right to void contracts that exceed meeting their basic needs such as food or clothing. As a result, minors have the authority to end contractual agreements, including employment agreements, without any legal repercussions. Credit card companies, for example, won't offer credit cards to those under 18 because they can just void the contract at any time. During the early days of the film industry, the infancy doctrine posed a significant challenge to production companies because minors could just void their contract at any time, potentially disrupting productions. In response, California legislation amended the Civil Code in 1927, allowing minors to relinquish their rights to void contracts with the judge's approval. This change allowed production companies to secure child actors under lengthy contracts by just getting a court's approval, thus mitigating the risk of them leaving and going to a competitor. And so companies like MGM only needed to get a judge's approval to make the contract legally binding for the minor. However, there was no set standard for any requirements that the contract had to meet to get a judge's approval, leaving little room for children to be able to get out of the contract if they wanted to. So as I said before, it wasn't until the 1930s that there was any legislation restricting child labor. The Fair Labor Standards Act, or FLSA, was enacted in 1938 to establish minimum wage, overtime pay, and regulate working conditions, including provisions aimed at protecting minors from oppressive labor practices. However, the act provides exemptions for specific industries, including the entertainment industry. So this meant that child actors a part of major motion pictures, theatrical productions, or radio and TV productions were exempt from the FLSA's age restrictions and working conditions regulations. This exemption is often referred to as the Shirley Temple Act. Representative Charles Paul Kramer of California introduced this exemption, arguing that child actors like Shirley Temple possessed exceptional intellectual gifts necessary for performing in motion pictures. He specifically stated, "The ability to perform in motion pictures requires an intellectual gift and quality, something which is born in the exceptional child. Not only the motion picture industry, but the movie-going public would be denied much pleasure and enjoyment if children were barred from the screen. The old and young are delighted with the unassuming appeal of America's little sweetheart, Shirley Temple." Congress, influenced by this perspective, determined that child acting contributed positively to the nation's economic and cultural life, and therefore did not need to be federally regulated. So yep, even today, there is no federal regulation on child labor in the entertainment industry. Instead, it is left up to the individual states to regulate regulate the experiences and treatment of child actors. And as of now, 17 states in the United States don't have any regulation on this, leaving significant disparities in the protection of children across the country. Because minors like 8-year-olds, for example, can't really consent to getting into the contract, we leave the responsibility up to the parents to decide whether their child should engage with entertainment work. And again, once the contract is approved by the court, it is legally enforceable, making it very hard for the child to get out of it if they wanted to. These contracts also often include clauses that hold parents financially responsible if their child refuses or fails to perform, including costs incurred by the production companies and attorney fees. So there's already inherent gaps in the law for protecting child performers. What happens when parents actually don't know what's best for their child? The regulations governing production companies often lack provisions that hold parents accountable for their actions and for ensuring the best for their child. The Coogan laws, named after Jackie Coogan, were established to somewhat address this issue. Basically, what had happened was Jackie Coogan grew up, and when he was 21 years old, he went into his bank account to check how much money there was, only to find out that almost none of it was there. So he took his mom and stepfather to court and got some of that money back, but this is what brought the Coogan law into effect. This law originally mandated parents to open a trust fund account for their child so that employers can put 5% of the child's gross wages into the account to set aside for later. Not every state has this law. Some states have an equivalent of a Coogan law, but again, since it's not federally regulated, it's pretty inconsistent. Also, 5% is really little, and fortunately, this has somewhat evolved. In the year 2000, the Coogan Act was updated to mandate at least 15% of the gross wages be put into the account. Additionally, parents and guardians no longer have access to the account, as it's now seen as the property of the minor exclusively. 15% is a bit better, but a lot of people in the industry would agree that it is still kind of a joke, because in the best case scenario, you have good parents who honestly set aside more than 15%, but still 15% is not enough to filter out the parents who force their children into the entertainment industry just for the money, because 85% is a lot and can be easily mishandled. Plus, the Coogan Act features loopholes that render child actors financially susceptible. For instance, Judy Garland's mother negotiated a stipend from her daughter's earnings in exchange for acting as Judy's guardian and ensuring compliance with the studio's directives. Similarly, Elizabeth Taylor's mother received 10% of her daughter's salary as Elizabeth's manager. When Shirley Temple at age 22 had asked about her bank account balance, her father, who was in charge of all her earnings throughout her childhood, had revealed to her that only $44,000 was left from the $3.4 million she had earned. That itself is such a huge gap and is way less than 5%, but let me put this in today's terms for you. So Shirley Temple was 22 in the year 1950. $3.4 million in 1950 is worth around $44 million today. That's how much Shirley Temple had earned. And in today's terms, $44,000 in 1950 is worth about $566,000 to $571,000 today. That's how much of her earnings as a child star was actually left to her. Additionally, Macaulay Culkin's parents, amidst a custody battle, squandered substantial portions of his earnings from Home Alone. A more recent example, Jeanette McCurdy, former actress from the Nickelodeon show iCarly and author of I'm Glad My Mom Died, she was notified in her 20s that her Coogan account information was never filed correctly, so she never saw that money. How that happened, I have no idea. The fact that it was allowed to happen, a huge, huge problem. And this is for California, right? We can also take a look at some other states and their laws. Florida, for example, has laws like California for child entertainment. Nickelodeon Studios, which has produced many of our childhood shows, operates in Florida, so obviously these laws apply to many child actors. Florida's laws were influenced by the 1995 Child Performer and Athlete Protection Act, and according to their laws, earnings from an approved contract belong to the minor, and there are procedures in place to ensure that this money is managed until they're an adult. However, the absence of a court's approval creates a crucial loophole. If a contract is not approved by the court, which isn't mandatory in the state, by the way, the earnings from that contract still belong to the parents. This sort of undermines the intentions to protect the child financially. New York is a bit better. They don't have the Coogan's law, but they do have a set-aside provision upon a judge's approval for their contracts with minors. Also, in New York, judges can set aside as much money as they deem appropriate for the child, whereas in California, there's a cap at 50%. Also, in New York, the cap for the length of the contract is 3 years, whereas in California, contracts with minors can be longer. New York also has specific laws for working conditions for minors, also requires permits from the mayor's office, and also has more laws to attempt to address education, welfare, and development needs. So we're starting to see how inconsistent these laws are because they vary so much between states. And we're mainly talking about finances. When you take an example like Jeanette McCurdy, who had an incredibly abusive parent, you can see how the law didn't exactly protect protect her from more harm. While we consider that there are some regulations when it comes to finances and when it comes to production companies, we also have to consider the fact that there are no regulations when it comes to situations in which a parent is abusive or don't care what's best for their child. Unfortunately, even when parents do the absolute best that they can possibly do for their child, it doesn't guarantee a safe and successful career because of how the industry fails them. I mean, one of the most highlighted points in Quiet on Set is that when you make studios money and you have that power, you can literally get away with anything. Jeanette McCurdy's memoir, I'm Glad My Mom Died, is such an incredible read, but it's also a very hard read because of what happened to her. Some of the things that she details in her memoir is the fact that the creator of the Nickelodeon show she was on, which we can assume is Dan Schneider, but she didn't name him, he would massage her when she did not want that. She was forced to wear a bikini on the show. She was also later offered $300,000 in hush money to not talk about her experiences. Obviously, she did not take that money. Another thing that we learned from Quiet on Set is the fact that Nickelodeon let go of Dan Schneider in 2018 and that there was an internal investigation that found him to be verbally abusive to coworkers and that he lacked appropriate boundaries with child actors. He was powerful and anyone who did or wanted to speak up weren't. In the industry, current guidelines advise parents to supervise their child at all times, often referred to as sight and sound. But there's also this added layer of protection with a studio teacher or a set teacher. This is because they not only provide educational needs, but they also safeguard their welfare. In California specifically, set teachers are meant to oversee the child's welfare until they're about 16 years old. However, of course, there are gaps to these measures. A studio teacher disclosed to The Wrap that she was removed from a production for speaking out against violations, which was entirely legal, by the way. Productions can hire subcontractors such as On Location Education, which is a non-union educational consulting company, so that studio teachers are not employees, but they are independent contractors. This arrangement allows for teachers to be replaced at any point for any reason on the production. In one instance, on the set of a Marvel show, a production manager insisted that a minor stay an extra hour past the legal limit to work, and the studio teacher did not like that and voiced the concerns for going over the legal limit, and then they were promptly fired. Marvel Studios declined to comment on this story. Carolyn Crimley, a certified studio teacher in California, experienced a similar situation in 1992 when she reported an on-set incident and was promptly fired from the production. So she was working for On Location Education at the time, which serviced many Nickelodeon shows in that year. And despite her reporting an instance of child abuse that she had witnessed on set, she was fired that very day. Her report to Child Services was also deemed unfounded because in their investigation they did it with the child's mother present, which probably inhibited the child from saying anything. Crimley, in sharing this story, also highlighted the common practice in the industry to keep parents away as much as possible. Kids themselves also feel like they can't speak up. Alexa Nicholas, an activist, YouTuber, and former actress on Zoe 101, detailed how when a child would want to voice any concerns on set, they would have to go to the union, which was SAG-AFTRA. SAG-AFTRA's whole process was to shut down set and conduct an investigation. The possibility of being exposed as a tattletale was too risky, so it highly discouraged kids from ever saying anything. And besides SAG-AFTRA too, there are extremely limited resources for child actors. Currently, I only know of an organization called Looking Ahead through the Entertainment Community Fund, which is supposed to provide mental health resources to child performers. This is supposed to help them financially, emotionally, and also with transitioning into adulthood, but really besides that, there's like nothing. There needs to be more programs like an informed consent program for kids. Here's another wild thing about the industry's standards and processes. Background checks didn't used to be a thing. After what had happened with Brian Peck, as detailed in Quiet on Set, background checks at Nickelodeon and Disney became a thing and have been a thing over the last 20 years. A Nickelodeon insider told The Wrap that background checks weren't a standard to begin with because unions don't like them. In 2013, there was a new California law stipulating that individuals such as publicists, managers, acting coaches, and headshot photographers working with child actors must undergo fingerprinting and pass an FBI background check to obtain a child performer services permit. However, a Deadline investigation in 2018 revealed that not a single Hollywood publicist representing minors had this permit. Numerous managers, acting coaches, headshot photographers also failed to comply with this law. And this is supposed to mean up to a year in jail or a $10,000 fine, and yet no one has been charged for this. Again, in California, anyone providing entertainment services to minors are required to carry this permit, including people in PR. While the investigation saw that personal managers had more compliance, there was still an equal amount of managers that didn't comply than the number of managers that did. And I feel like I need to emphasize that these are managers of child actors in very popular children's shows on Nickelodeon and Disney. Disney. And despite advocacy efforts from groups like the Talent Managers Association, there is still non-compliance in the industry. And despite significant taxpayer spending on the database and the processing of these permits, there has been minimal enforcement from the law. It is evidently incredibly bizarre that this is happening in 2024, that there's barely any laws to protect child performers, there isn't really any checks and balances on the parents, and that there's so much negligence happening in the industry with the adults that work in it. And while I've covered the lack of care for child actors in a more legal sense, I also think it's important to cover the lack of care for their emotional well-being in the industry. There is currently no directive in child labor laws for requiring psychological counseling for child actors. This can be bad because even if a child actor doesn't experience abuse, it is still a career that is very hard to navigate at such a young age. Allison Stoner, in an op-ed in 2021 for People.com, recounted an experience auditioning for a kidnapping and assault scene at 6 years old. As with many parents in this unusual situation, my mother is not versed in how to help me regulate my nervous system. I remain catatonic on the first half of the drive until I remember we're en route to a second audition for a princess toy ad. On the spot, I manually alter my mood, personality, and outfit so I can win over a new stranger with a camcorder. I need to outperform 900 other candidates. Stoner stands on immediate solutions to improving child actors' well-being as having a mental health professional on all sets. There's also the rejection side of the industry that's very tough for kids. In Quiet on Set, actress Raquel Lee from The Amanda Show and The Proud Family detailed having been fired from The Amanda Show and how traumatizing that was for her. She said, "I'm questioning, is it because I'm black? I'm questioning, is it because they don't like me? I'm questioning, is it because I'm not good anymore? It's terrible." And then of course there's the huge issue with the objectification of child actors on and off set and the lasting effects that can have. Many child actors over the years have talked about the specific issues, such as Mara Wilson, Scarlett Johansson, Millie Bobby Brown, Taylor Lautner. I'm pretty sure every child actor has experienced something like that at some point, and that is very fucked up. So where does that leave us? To address the very clickbaity question, should we ban child acting? There's this Huffington Post article that I read that poses this same question, and the writer of this article had asked a clinical psychologist that works with child performers and has consulted SAG-AFTRA what sets child acting apart from other oppressive forms of labor. And his answer was that what sets it apart is that the child wants to be there. Children don't want to work in mines, as he more or less put it, but oftentimes the child has a drive and passion for performing. And we shouldn't take that away from them. On this subject, Raquel Lee also added in her 2 cents. You can't remove child acting from the world. We wouldn't have Drew Barrymore, we wouldn't have me, we wouldn't have Kyla Pratt, we wouldn't have Christina Aguilera. Does it mess you up? I'm sure all these women I just said, I can probably have a therapy session with each and every one of them because we've all been through something. But I'm sure that for all of us, this was our calling. So maybe not banning child acting, but there definitely needs to be more comprehensive federal legislation to address the welfare of child actors. What could that look like? I wish I had the credentials to propose my own thought out solution, but one proposed solution I read about in this study that I'll link below is the idea of a federal oversight board in the Department of Labor. This board would require each state to submit a child entertainer welfare plan outlining protections in areas like finance and education and psychology. States would have the freedom to still regulate child actors within their own bounds, but they would have to submit a plan. The Federal Oversight Board would monitor and ensure compliance with these plans, conduct investigations, also get input from industry professionals. The Secretary of Labor would enforce the terms of the plan, and the children and their parents or guardians would have the right to take legal action if they wanted to. Because although some states like California, Florida, and New York have some regulations on child acting, the industry is ever evolving and every state should have regulations. A Federal Oversight Board would hopefully establish consistent protections nationally. There's no fun way to end a video like this, but I do hope it was informative. Obviously, it is very unsettling to sit with the information that we learned from Quiet on Set, but I do hope that encourages more people to speak up and for more people to advocate for change. Because I think by addressing financial, educational, and psychological needs, we can better protect these child performers and ensure that they have a healthy and successful future. Thank you so much for watching this video. Definitely like it and share your thoughts if you have any in the comments, and subscribe if you haven't already.